All right, so we'll start with CPC, Code of Civil Procedure. And then, so have you bought any books or anything for CPC?
No books. Only I have a syllabus with me. And
Okay.
yeah.
All right. You can also download this BEAR Act, the BEAR Act, like it's not book, the main legislation, what is there in CPC. You can just go through the provisions and what all sections are there in your free time. You can just scroll through this document as well. Okay. So now starting with CPC, I know you must have studied different legislations already, like IPC and stuff. You must have already got that part, right?
Yeah.
Okay. So usually in a legislation, all the provisions that we have, they are arranged in the form of different sections or in the form of different articles, like we see in Constitution or in some international conventions or treaties. There will be certain articles where provisions will be arranged. Same ways for other legislations, it's usually like different parts or different chapters will be there. Inside that, there will be certain sections. So when we talk about parts or chapters, they are like broad areas which the legislation talk about. Like here we have suits, here we have parties to the suit, all those provisions that we have, execution. They are the broad areas. Under execution, again, all these specific provisions will be given in different sections. So that's how usually a legislation is arranged. Now, once all the provisions are given, they are like the main provisions talking about rules, regulations, powers, functions, rights, obligations, and all that. Once that part is over, sometimes, not like for all the legislation, but for some legislations, we get another part which is nothing but schedule. Okay, it might not be present in some legislations, it may be present in some. For CPC, we have some schedules. So any idea what schedules provide for? In any legislation, might be in Constitution also, you must have got, there are different schedules to the Constitution. So what are schedules?
Not remembering.
Okay. So schedules are basically nothing but like some additional information, okay, some extra information. In case of other legislations, like in case of Constitution, schedule is like an additional information which if you want, you can refer. If not, also you will understand the Constitution. But for CPC, schedules are very important. Okay, like how sections are important, schedule is also equally important. There used to be a total of 5 schedules, but as of now, these are being repealed. So we just have one schedule. Okay, so there some rules of procedure are being mentioned, certain orders are also there. Plus we have some appendix, like certain forms and other things are being mentioned there. Okay, so for other legislations, schedules might not be that much important as it is for CPC. Like we have a legislation called Specific Relief Act. There also the main legislation, there are certain sections. You can simply study that part. It will be enough for you. Schedule is just an additional information. But for CPC, schedule is also equally important as compared to the other part. Now, the entire syllabus for CPC and for any other subject for that matter for KSLU, it's divided in 5 different units that we have. So the first unit for CPC, these are the topics that we have, like the intro part, then difference between substantive and procedural law, history of CPC, application of CPC, jurisdiction of civil courts, suits of civil nature, res sub judice, then res judicata, foreign judgment, place of suit, transfer of cases. So all these topics are given there. Today we'll start with this intro part plus the differences. Okay, this part we will be covering. Now, civil and criminal, are you aware of the differences between these, like 2 broad areas of law?
in terms of example, if we look into tort is civil, contract is civil. And also in terms of the what we can say, the remedy, it will differ in between civil and criminal.
Okay.
In civil, it will be minor, or it can be injection, or it can be providing compensation, whereas in criminal, usually it will be imprisonment, depending on the severity of the crime.
Yeah. Let me open one document. Civil and criminal will just look like how they are different. Okay, so when we talk about difference between civil and criminal, there are a lot of different areas, different grounds based on which we can say that they are different. Okay, first of all, civil is like a dispute between mainly two individuals or two organizations, or between an individual and an organization. Like you said, contract, tort, these are disputes between two individuals usually, right? So it might be a dispute between you and me, that will be civil. It might be a dispute between you and KSLU, that you have completed the course, might be there is a delay from their side in providing the final certificate, that will again be civil. But when we talk about crime, it is considered that even though crime also is committed against one individual, right? If it's murder, one person is killed. If it's kidnapping, one person is kidnapped. Even then, for crime, it's considered as if the crime is committed against the society at large. Okay, because it's assumed that in India, state is having a responsibility to ensure our safety. So if some crime is committed, it's as if state has failed in its duty. And why did the state fail? Because someone else committed a crime. So for crimes, it's considered as if it's not committed against that one individual, but against the society at large. That's why for most of the criminal cases, you will see state being a party. Okay, like Shabnam versus state of UP. State of UP is the party, not her family members whom she killed. Same ways it might be Union of India. Okay, so for most of the criminal cases, state will be a party. There might be some others where state is not a party, it's just individuals, like a check bounce case. State will not be a party in such case. Okay, so civil is like a less serious crime, criminal is more serious. Because its impact is more serious, punishments are also more serious, like capital punishment, life imprisonment, rigorous imprisonment, simple imprisonment, fines, so many different types. For civil, as you said, injunction, compensation, specific performance of contract, so many types we have again. And examples, you are already aware, landlord-tenant dispute might be, rent control matters, divorce proceedings, child custody, property dispute, breach of contract, all of that would fall under civil. And for crime, all the crimes given under IPC and so many other legislations we have for that matter. Now, when we are studying CPC, it will be for these matters, right? What process or what procedure is applicable for these kind of suits or these kind of matters that we need to look at.
And what about the assault? Because even in tort, we discuss about assault.
Yeah.
Right?
There are certain, there are certain crimes which are like specifically civil, certain crimes which are specifically criminal. There may be some crimes which fall under civil, also criminal also, like assault is there. Then defamation is there. Contempt is there. Okay, so depending on how the crime is committed, sometimes we can specify that, okay, this is civil or this is criminal. And sometimes it just, like for defamation or for defamation, it's on the person, on the victim, whether he wants to proceed with a civil suit or a criminal. Okay, but in case of assault and contempt of court, we need to see what all ingredients were present, then we can say whether it falls under civil or criminal. So there are certain classifications of crime which may fall under both as well.
Okay.
Okay. Yeah. So these are the topics which we have in Unit 1. So first of all, starting with the intro part. What is CPC basically? Civil Procedure Code. Before starting that, we should know that laws are broadly classified into two groups, substantive and procedural. Have you studied this part or heard of it? This classification of law?
No, not recollecting.
Okay. So when we see this word, right, procedural, as in there is some procedure. Okay, there is some procedure involved. Now, for everything, there is a procedure, right? Like you applied for this course, LLB, 3 years LLB course in KSLU. It's not like randomly you just went to the classroom and started attending classes. There was some process that you had to follow. You had to fill some application form, give your documents, details, and everything. So there was a process to take admission. There will same ways be a process to attend up or appear for exams. For every single thing, there will be some or the other process that we need to follow. Same ways, when it comes to approaching the court, we cannot randomly go to any court that we feel like. There is a process set for that also. What loss or injury have you suffered? For that, which is the right court that you can approach? When to approach? How to approach? For every single thing, there is a procedure set. Okay, and how will we come to know about this process? Because there is such a huge population in India. So many courts are there. People want to approach court for some or the other matter. So it's not possible that one person will like inform or pass on the rules or process to the other. It's not possible that it will be like orally transferred from one person to other. It has to be there in a written form. In a proper written form, all the rules, all the procedure, everything should be there, so that whenever we feel like we can refer that, we can understand what is the rule, what is the procedure. Okay, so there is a section of laws or legislations which only tell us about the procedure. It just tells us how to approach a court, which court to approach, when to approach, and all that. So that part or that section of legislations will fall under this category called procedural laws. It only tells us about a certain process or a procedure. Okay, that is one section of laws. Then what might be substantive law? It's like substance, we say, right? What is the substance? Like, what is the main thing that is there? So substantive law is nothing but it provides for that main thing. If laws are there, for what reason are laws? Laws are to provide for some rights, to mention some obligations or duties, right? Like IPC. Why is IPC there? What provisions are there? If someone asks you, like, what is IPC all about?
Yeah, it's Indian Penal Code, and
yeah. So what all things are mentioned there? You have got that right in first semester or not yet?
yes, yeah. We just study for the exam now. That's why.
Yeah, correct.
That is the problem. Yeah. Yeah, it defines the crime and the penalties.
Yes. So it defines the crime, plus it also talks about the penalty. It also talks about the punishment or consequences. What will happen in case we are not fulfilling or we are not following the provisions given under IPC? What will be the consequences for that? Everything is mentioned there. So that means IPC is mainly talking about rights and obligations. If IPC is saying that murder is a crime and this is the punishment for it, IPC is giving us a right or an assurance that, okay, fine, we will not be like killed that easily by someone, right? Even if we are killed, that person will get punishment. So it's mainly talking about rights and obligations. Same ways for Indian Contract Act. It also talks about rights and obligations. If you have entered into a contract with someone, you have a right to ask for performance of that contract. It's about your right and obligation of the other person. So substantive law is mainly that part of law which establishes rights, duties, or liabilities of individual, like IPC, Indian Contract Act. Any other example that you can think of? Substantive law that is providing for some rights or obligations.
What about in the Constitution also we have rules and
Constitution, yeah, Constitution also we have, it is considered as like a supreme law. Okay, it just broadly talks about all the things. All right, so when we talk about these things, it's not like procedure as such, it's not about substance also as such. Both the things are there. Constitution is like a supreme law. Below that, all these other legislations come. So this classification is usually used for these other legislations that are there. Okay, because Constitution is just main things. Broadly, it is talking about everything, just setting the process right so that India can function properly in that ways.
Right. Labor law we can correlate.
Yeah, labor laws we can say. Minimum Wages Act, Maternity Benefit Act, Payment of Bonus Act, Factories Act, Industrial Disputes Act, trademark, so many are there. Correct. Those we can say, those are substantive. We can say Income Tax Act, we can say all the environment related laws. All these are substantive because they are providing for the content, right? Like what is the crime, what is the punishment, what all are our rights and obligations. Next is what it consists of. So substantive law consists of written statutory rules passed by legislature that govern how people should behave. It is, laws are usually passed by the parliament or state legislature, depending on whether it is coming under central list, state list, or concurrent list, it will accordingly be passed. Now, they will govern how people behave. They also define our rights and responsibilities as a citizen. Law will not talk about the moral obligations that we have. Like you should be helping people in need. That is just a moral obligation, right? It might not be practical that we just keep on helping people whomever we see in need of help. So law will only tell about the minimum expected thing, the least minimum expected behavior from us. And what is it? It is expected that unnecessarily we are not going and killing someone, hitting someone, injuring someone. That is the least minimum thing we can do. And that is provided in substantive law, like we have IPC. There is provision like assault, there is provision like defamation, there is provision like hurt, murder, so many. So it is the least minimum expected behavior that we are not supposed to behave in that way. Otherwise, we will have to face the consequences, the punishments for it as well. So what all our rights as well as responsibilities as a citizen are, or as an individual residing in India are. Procedural law tells us how legal case will flow. What are the steps, different steps or different processes involved? After which step, which one would come, right? Entire process is in a very clear way explained and given in the procedural law. So when we look at the procedural legislations, we get a clear idea on how a certain case will proceed. That is given in procedural law. This part is clear, right?
Yeah, procedural law example, this is clear. Substantive law, we have, like as I said, labor law. Or,
yeah, procedural example. Correct. We are coming to that also. Procedural. Yeah, we will come to that. Okay. Next one is what it determines. So determining what facts constitute a crime is subject matter of substantive law. That means it will tell what all. Usually when we study a crime, there will be certain ingredients or certain elements that should be present, right? Like in case of theft, In case of murder, there has to be certain elements or ingredients that should be present. Like in case of theft, guilty intention, movable property, moving of the thing, so many ingredients are there. Okay, so substantive law will tell us what all ingredients or elements are needed to constitute a certain crime, plus what will be the punishment for commission of that crime. In case of procedural law, it will determine which court has jurisdiction to try the matter is a matter of procedural law. What is jurisdiction? Are you aware of this word? Jurisdiction of court.
Yeah.
So what
is like a area or
correct. So jurisdiction.
Trial has to example like trial has to be done in the area where the crime has been committed.
Correct.
The same jurisdiction.
Yes. So actually jurisdiction is like reach. Like to what extent you have your reach, like that to what extent court is having its reach. So jurisdiction, there are actually different types of jurisdictions. The one you are saying is called as territorial jurisdiction. That where the crime has taken place, where the wrong has taken place, within that jurisdictional area, case will be filed. Territorial jurisdiction. There is something called as subject matter jurisdiction, that for these kind of matters, like check bounce matters, it should go to magistrate court. That is subject matter jurisdiction. What is the wrong all about? It is check bounce. Like that. There might be certain jurisdiction called as pecuniary jurisdiction, depending on how much of punishment it is. Okay, like magistrate court cannot give death penalty. So depending on the punishment, we are fixing jurisdiction. Like that, there are different kinds of jurisdiction. So you are correct. Jurisdiction is nothing but which is the right court, whom we should approach. It might be depending on territory, like you said. It might be depending on subject matter. It might be depending on punishment or other factors. So procedural law will help us decide which is the right court whom we should approach. Okay, so it will tell us about jurisdiction, everything about jurisdiction, like we have seen in the syllabus also. There is this part in first unit itself, jurisdiction of civil courts, right? So it will tell us which is the right court that we should be approaching. Now, substantive law relates to matters outside the court. If a certain crime has taken place, if a murder, kidnapping, theft, assault, defamation, whatever has taken place, ideally it will happen outside the court. Theft at a dwelling house, theft in some shop, defamatory statement published in a newspaper, magazine. It is a matter outside the court. Something has happened outside the court and we want a relief for that. That because of that reason, we are going to the court. So substantive is usually matters outside the court. What has happened, how the crime took place and all that stuff. But when we talk about procedural law, it deals completely with matters inside the court, because it is telling you which court you should be going to, within what duration you should be going to the court, right? After which process, what will be the next step? Everything is matters within the court. Okay, within the court, how things will go on. That is nothing but procedural part. So substantive is like outside the court, what has happened. Procedural is like inside the court, what will happen, how things will go on. And like you said, examples. Yeah, examples, we have plenty of examples for substantive law. Like I said, Indian Contract Act, IPC, Income Tax Act, Karnataka Police Act, and so many others. For procedural law, we have two main important laws, that is Code of Civil Procedure and Code of Criminal Procedure. So Code of Civil Procedure tells us how a civil suit would go on, what all different steps, processes, everything about civil suit, it is given in Code of Civil Procedure. Same ways, for a criminal case, criminal case would be different as compared to a civil case. So for that, we have code of criminal procedure that tells us the different process, different stages of a criminal trial. Same ways, we cannot, we cannot pick any random things and dump it in the court saying that this is an evidence. Evidence also should be presented in a certain proper way. There are classification of evidences also. What evidence is admissible, what evidence is not admissible. Everything we have rule for that. We have a process for that. So we have a legislation called Indian Evidence Act that tells us what all evidences are admissible, how to produce evidences before the court. I think Evidence Act you have not yet got, right?
Yes.
Yeah. You are in which semester, by the way?
I'm in fifth sem, 3 years.
Okay. I guess it's in last semester then. So Indian Evidence Act is also one procedural law because it tells us about the process, how evidences will be presented, what evidences will be presented. Okay, like there was this thing on news, right? Shah Rukh Khan's son, when he was arrested for investigation and stuff, that WhatsApp chats, are these admissible evidence or not? Right? Have you heard that in news? It was too much in news that WhatsApp chat should not be like an admissible evidence. Right. Same ways, there are so many things like hearsay evidences are also like not accepted as like a valid evidence. Like we used to play this game like Chinese whisper, where we need to just whisper some statement to a friend's ear, and then it will go on in a complete circle, and then this last person will hear something which is like completely not related to what started, right? So that gives us an idea that how, like non-reliable hearsay evidences are, because while playing a game, it's just one simple statement like earth is round, that statement can go and become like grass is green, right? We have witnessed that thing ourselves. So that indicates that hearsay evidences are not at all reliable. You saw something yourself, you are the eyewitness, you can appear in the court, but you told your friend something, your friend said your friend something. After that, after like 5-6 persons, it came to me. So here and say something I have heard and I'm saying that. It's not reliable at all. So all those rules and processes are mentioned under Indian Evidence Act, and that also is a procedural law which we have. Same ways we have Limitation Act. Are you aware what Limitation Act is? I think it's part of CPC only. Limitation Act, have you heard it before?
I have heard, but not much in detail. No.
Okay. So limitation as in some limit is being put. Okay, some limits will be put. Now, what kind of limit is it? It is limitation relating to time. Okay, when something has happened, some loss, some injury, something, whatever has happened, you do not have your entire lifetime to file a case. Okay, when something has taken place, you have a limited time to file a case to approach the court. So that limited time is mentioned under this legislation, Limitation Act. It may vary depending on the type of wrong that has taken place. Like for example, I have taken 10,000 rupees from you and I said I will return it within 2 months. Okay. Now, 2 months gone, I'm not returning it. After 2 months, you should be asking for the money. Okay. You ask for the money, I'm not returning. When I'm not returning, right, from the day when 2 months ended, you have 3 years of time to file a case against me for recovery of money. If you fail to file the case within this 3 years time frame, after that, I'm not legally bound to return you the money. Okay, there might be some exceptional cases where you request the court that I had so and so valid reason for not approaching the court, and court may accept your condonation, but ideally within 3 years you should be approaching the court. That is nothing but limitation. It is given under Limitation Act. Same ways might be you purchased a plot of land, okay, and it is in Tamil Nadu you purchased, and now you are living in Bangalore. You are not going to Tamil Nadu that often. Someone occupied your plot of land and they are wrongfully residing there. One day you went there, you saw them residing there. You are not filing the case still. Okay, so the day when someone wrongfully occupies your plot of land, you have 12 years of time frame to file a case. Within 12 years, you should be filing a case. Like that, for every single matter, there will be some limitation, some time limit fixed for you to claim your right to file a case. That again is a process, right? Within what time you should be approaching the court. So that also falls under procedural law. Same ways we have Court Fees Act, Suit Valuation Act. They also fix the amount which needs to be paid to the court and everything. These are also court-related process. Inside the court, what will happen? What will be the value of the suit? How much court fees need to be paid? All these are again matters within the court, how the process would go on. So all these legislations fall under procedural law. Out of these 3 are very important. You get it as a complete subject as well. Limitation Act, it's a very small legislation. So usually it is given as part of CPC, like one unit in CPC, and same has happened for your syllabus as well. Okay, so CPC.
Ma'am, what notes you have shared, that is only the bare acts, right? Looks like this notes is not shared.
Yeah, this notes is not shared. This one I will share like PDF copy only on your WhatsApp. I'll share.
Okay.
Okay. Okay, so substantive and procedural, this part is clear, right?
Yeah, that is, very clear.
Okay. So CPC falls under the procedural part. It tells us how a civil suit would proceed. What are the stages, steps involved, and everything. Now, when we look at CPC or Code of Civil Procedure, it can be divided in it has mainly 2 different things. Okay, so it is having 2 different things mainly. It is having 12 different parts, like I had already shown you. Usually, a legislation is divided in different parts or chapters. For CPC, it is divided in parts, and total of 12 parts are there in CPC. Okay, then we have 158 sections in those 12 parts. We have 158 sections. Now, these sections lay down the general principles relating to power of court, like jurisdiction, suits, all those matters are given there. Okay, these are like general provisions relating to powers and stuff. Plus, we have one schedule as well, wherein we have 51 orders. Now, what this schedule is all about and what these orders are all about, these are the procedures, methods, and manner in which jurisdiction of court may be exercised. So this is like a practical thing which is given. We need to study both these things together to understand what all things go on inside the court for a civil suit. Okay, so mainly you need to remember this thing, that there are 12 parts, 158 sections, and there is one schedule along with 51 orders given there. Okay, so CPC consists of body of the code plus the schedule. Body of the code has 12 parts and 158 sections, and schedules is like a second part which contains orders as well as rules. It lays down powers, body of the code, and schedules talk about procedures, methods, and manners, etc.
Okay, from the origin itself, there were so many sections. Are there any amendments being made?
Amendments are there, few sections are removed, few sections were amended, like that it has happened, but yeah, these many were only there. Okay, few sections you will
Currently,
see.
so many.
Yeah, currently
Okay.
that many are there, because see, these all you see, right, these are like added, these are being added, these are being repealed. Okay, so these are how many sections we have as of now in CPC currently.
Okay. Okay.
Same ways, when the code was enacted, there used to be 5 schedules, but currently we just have one schedule that provides for 51 orders. Plus, there are this appendix as well, which are nothing but certain forms relating to pleadings, process format, discovery, inspection, admission, decrease, execution, supplemental proceedings, appeal, reference, reviews, miscellaneous, and all that stuff. Now, provisions of body of the code can be amended only by the legislature. It again has come from the legislative department, right? So the legislative body only will be having the power to make changes in the body of code if something is needed. Because it's a very old legislation, it is obvious that we need certain changes, right? For it to be valid in the present day situation, we definitely need some changes. So those amendments were being made. Certain things you will see repealed, omitted, and stuff. That is completely okay. But still, this legislation of 1908, it is still being valid and serving its purpose, right? So that is the main thing what we have. So any doubts from this part?
No, as of now, it is clear.
Okay. So we have one part on history of the code also, like what all legislations were there before CPC came. Then we have application of the code. Is it applicable to entire India or not? Then we have jurisdiction of civil codes, like what all different types or kinds of jurisdictions that are there. So this part we will continue in the next class. After that, only the proper legislation will start, okay, which is like suits and these all doctrines and all that stuff. This proper provisions will start only after that. So this was like an introductory part. I will share 2 links with you where you will again get the substantive, procedural, civil, criminal part. You can go through that, be clear on that part, so that it becomes easier for us to understand the main provisions of CPC. Okay.
Sure. Yeah.